The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Friday, the 3rd of June, 2016, are currently trading with gold at $1,243.80 an ounce, silver $16.39 an ounce, Texas crude $49.17 a barrel, and Bitcoin is currently steadily rising at 573 U.S. currency. Today in history, the year 1784. The U.S. Army is officially established by the Congress of the Confederation, created to replace the disbanded Continental Army after the Revolutionary War. The U.S. Army was founded. Today in history. In recent news, the Brazos River, which runs 840 miles across much of the Lone Star State, has already risen to record levels, flooding neighborhoods west of Houston and forcing hundreds of people to evacuate, with worse news coming from the National Weather Services predicting another 4 to 5 inches through the area in the weekend. Just as last April, if you recall, more than 1,000 people were evacuated from northern Houston during another historic flood. In Austin over the weekend, more than 2,000 inmates were evacuated from prisons in low-lying regions. Consider that just 2 years ago, the Brazos River had run dry in some places due to drought, but is now in an obviously saturated state. A flash flood watch is currently in effect for all of south central Texas, according to the National Weather Services, and a river flood warning is in effect for the Brazos River. At least half a dozen fatalities have been a consequence of these floods. In what could be some of the most eyebrow-raising endorsements for presidential hopefuls of the United States, the president of Venezuela, Nicolas Maduro, came out and endorsed Democratic Socialist Bernie Sanders on Tuesday, calling him our revolutionary friend, and implying that it is our broken political system as to the reason why Sanders is being marginalized. If that wasn't enough, North Korean state media, DPRK Today, published a column also released on Tuesday, which came out and endorsed Republican newcomer Donald Trump, calling him a wise politician, and stating that it turns out that Trump is not a rough-talking, screwy, ignorant candidate they say he is, but is actually a wise politician and pristine presidential candidate. As of yet, no authoritarian dictator has come out and endorsed Hillary Clinton, though some suspect this is due to many of them wanting to retain some level of credibility. In what could only be considered ominous omens, it seems that many of black cats are crossing the American people's path to this upcoming presidential election. The Lone Star Lowdown is currently looking for sponsors. If you have a product or a service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This is Rick Rohde with your Lowdown for June 3rd, 2016.
Hi, you are listening to Rule of Law Radio with Randy Kelton, Vet Pack. It is June 3rd at 8:03 p.m. And in Randy's terms, he's going to be talking about dirty, rotten lawyers. So, Randy, go ahead.
Yes, so we are planning on coming down, I think the 22nd, 23rd. The State Bar Association is up for sunset. So we're going to go before the Sunset Commission, and we're going to give a presentation. Ken Magnuson, he's pretty good at lobbying. He's a lot better than me. I'm a little too coarse. But he's going to give a presentation asserting some changes he would like to see made. And I'm going to speak to him, and I'm going to ask him not to change anything. Because the State Bar Association right now, I'll tell them that I do this radio show, and I tell everybody that if you file a bar grievance against a lawyer in Texas, the State Bar is going to get that bar grievance, and they're going to throw it in the trash. And then they're going to send you this letter back saying that we examined into your accusation and find it does not rise to the level of misconduct. Makes no difference what you file. You're going to get that response back. It's what the bar does. We have lawyers regulating lawyers. So what would you expect them to do? And that's a great thing. And I tell everybody, that's a good thing. The reason that's a good thing is their insurance carrier knows that they'll throw it in the trash. Here's what I was doing a little research on the underwriters for lawyer malpractice insurance. I've got a little article here. I'm going to read the first part to you guys. You are going to like this. Okay. If there is one thing you need to know about your legal malpractice policy, is that the reporting requirements for potential claims and actual claims. Although many lawyers understand that they must immediately report actual claims and lawsuits lawsuits brought against them, they do not realize that they must also report any circumstance of which they are aware and that may result in a claim or suit against them. The failure to immediately report these potential claims will result in lawyers losing the coverage they counted on and paid for, and paid big time for. The good news is that you can avoid this problem if you understand the policy insurance application. Where does it say that I have to report potential claims? The notice provisions of many policies require that the insured give notice of all circumstances that would reasonably be expected to give rise to a claim. Even if the policy only requires that the insured give notice of a claim, some policies define a claim to include circumstances that the insured should reasonably expect will result in a claim. Additionally, your original application for the policy and each renewal application will inquire whether any insured is aware of circumstances that would reasonably be expected to be the basis of a claim. The applications require the insured to make inquiry of all these insureds under the policy before answering this question. The extent to which you will have to poll former partners, associates, and employees about potential claims they might be aware of or will depend upon your policy's definition of insured and the actual questions in the application. What is a potential claim? Most policies do not define a reportable potential claim beyond phrases such as any act which could reasonably be expected to be the basis of a claim. Courts have interpreted these phrases many times and have found them unambiguous. A claim is usually defined to mean a demand for money or services and might also include the filing of a disciplinary complaint. The standard for determining whether an insured should have been aware of a potential claim is often a combination objective-subjective. Well, it's also a combination objective-subjective one. The court first looks to see what information the lawyer actually subjectively possessed and then determines whether an objectively reasonable insured would have recognized the potential for a claim based on this information. Thus, even if you were not conscious that your conduct would likely result in a claim, you might have a reporting obligation if a reasonable insured would have foreseen a claim based on the same information you had. Among the circumstances where courts have found that the insured should have foreseen a claim are the following. The lawyer realized that he had failed to file tax forms or notices by a particular deadline. The client threatened to sue if the lawyer did not cure a problem. The client expressed this dissatisfaction with the result of a case and that he believed the lawyer was responsible. The lawyer was aware that he had breached one of the state disciplinary rules in his business dealings with a client, and the client loses a case in the trial court because of some act or omission that was within the lawyer's control, such as a failure to make an objection, failure to designate an expert or otherwise respond to discovery request, spoliation of evidence, failure to prosecute, or failure to file within the statute of limitations. This is really cool. Okay, you need to understand what that reporting requirement goes to and why you find court cases relating to that. Because if you have a reporting requirement as a lawyer and you don't report these claims or potential claims the way the contract requires you to, then if you get sued, you're not covered. These guys start out paying $25,000 a year. And it goes up from there. First bar grievance, they have to report bar grievances, then it doubles. If it's in the first year of practice, they'll cancel. 2, in any 1 year of practice, they'll cancel. 3, they'll cancel your law firm's malpractice insurance. So I'm going to go to the legislature and ask them, don't sunset the bar. Keep that bar just the way it is. Frankly, I think it's wonderful. It is the greatest check to the abuse of power by lawyers that we could possibly have. And the best part is they created this mess for themselves so they don't get to whine and gripe about it. That's my story. I'm sticking to it. What do you think, Vet?
I think that was pretty good, actually.
When I read this, I was surprised that the reporting requirements were a lot higher than I anticipated. And this gives me an idea, is you should always communicate your dissatisfaction with your lawyer in email or a written letter, but email is sufficient. So it's in writing. Just a verbal admonition is too ethereal. When the sound dies down, it all goes away. But if you do it in email, then it's essentially permanent. It's even more permanent than written mail because you can lose the mail or you can lose the green card. The email.
Do you know the email address?
Oh, it'll be whatever your lawyer is. And
okay.
The reason I was researching is I'm trying to find all the underwriters. I want to get a list of underwriters and email addresses for underwriters and create a CC list so that every time we file a bar grievance, we CC every underwriter. Every time we file a complaint, we complain to the lawyer about a problem. Say and a lot of us, we try to get lawyers to file documents and they refuse. I should get a letter to their insurance company. You email the lawyer and CC it to the insurance company so the insurance company has notice that you're requesting your lawyer take some action toward the adjudication of your case and he's refusing to do so. I mean, how many times have we heard people say that they tried to get the lawyer to do things and the lawyer just refused? I mean, those listening to our show, they get that all the time because they're asking the lawyer to do things that are required in the adjudication of their case. And the last thing they want to do, especially if they're like a court-appointed counsel, the last thing they want is to get the client off. Because that's not why they're there. That's not why the state's paying them. The state's paying them to make sure they don't have anything to appeal. I had a friend that a lawyer actually told him that once when he was pretty frustrated at him. Told him, you don't understand. My job is to make sure you don't have anything to appeal. So knowing that, we better understand why these lawyers don't want to file some of these documents, but it puts them at terrible risk. So from my point, they keep doing the State Bar Association just the way they are. It works fine for me. If the State Bar did their job the way they should, then a frivolous or meritless grievance against a lawyer would be ineffective. But they created this mess where we have this giant club we can beat them over the head with. And if they raise a complaint about it, I just had someone tell me that in a pleading, the lawyer complained to the judge about all the bar grievances he had filed. And I asked him, did you file a bar grievance against him for that? And then a petition for sanctions against the lawyer for attempting to improperly influence the court. So when the Sunset Commission meets, it should be about the middle or toward the end of January. Anybody in Austin, you might check with the legislature, find out when they're going to meet. The more people we can get there, the better. They may actually change something if I can get them to realize their failure to act has caused a horrible problem. We are going to go to calls. We've got 1 minute before we drop off for break. So when we come back, Chris, I see you there. I've got the phone lines open. We'll keep them open all night. So if you have a question or comment, give us a call. Best to call in early. We only take 4. We can only hold 4 callers at once. So if the call board fills up, then it's kind of hard to get in. And it generally fills up toward the end of the night. It gets a lot busier. So if you have a question or comment, you want to get it in, call in early so we can make sure we can get to you. Okay, Miss Vet, you want to take us out?
Sure. All right, this is Rule of Law Radio. Randy Kelton, Vet Pack. Please call us at 512-646-1984 with any questions that you may have. We will be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
We are back. You're listening to Rule of Law Radio. It is June 3rd, 8:19 p.m. and Randy Kelton, Vet Pack. We have got Chris on the line. Randy, did you want to go ahead and bring him on?
Yes, I did. Hello, Mr. Chris.
Hello, Randy. How are you?
I am good. Tell me you got a ruling on your default.
Well, it's an interesting scenario. The judge today put a stay on the sheriff sale. He actually allowed the summary judgment to go through and put a stay on the sheriff sale today.
Wait, so he granted your summary judgment?
No, he granted their summary judgment, the banks.
Oh.
But put a stay on the sheriff sale.
Because he knows you're going to appeal. That's odd that he would do that sua sponte. But did you ask for a restraining order?
We asked, the attorney asked to put the sheriff's sale on a stay. That's all she asked for today, and he said he's going to allow the summary judgment, but put the sheriff's sale on stay. That's what we were told.
Yeah, I think he knows. You know, if it's the way I think it is, he's been paid for,
Right.
and
That's what we've been
he's pretty sure that the way the political winds are changing, he's going to get overturned. But he has plausible deniability when he goes to his bosses, the banks that paid him. I ruled in your favor, but you know how those dirty, rotten appeals courts are. We are getting a lot of traction in the appeals courts. So things are moving in our favor. So that sounds good.
Yeah, we had the attorney's going to put in an appeal. She's going to put her 1925 form in. Been talking to Leslie about it, and we're going to file this as soon as possible and see where it goes.
It'll probably be another 2 or 3 years before they get this done. You got 30 days to give notice of appeal, then 60 to 90 days to file the appeal, and the other side has probably 30 to 60 days to respond to your appeal, and then the judge will take a year to year and a half to render a ruling.
Yeah, well, our statute of limitations should run out by then.
And then if it all gets dismissed, then, well, you have enough claims. If they actually go by law, then they're going to lose anyway.
If they go by law.
And the courts are beginning to move in that direction. So it's getting better. It's only taken 6 or 7 years, but they're finally beginning to see that this problem's not going to go away. It may be that the banks are running out of money to pay these judges. I know that's tacky to accuse these judges of being paid off. And maybe they're not, but they're sure acting like they are.
Yeah. I can't see any other reason why a judge would sit there and look at the bank not holding the mortgage and giving them a summary judgment when there's subject matter here to be discussed at trial.
Bought and paid for. We need to start working on elections and see if we can't get these judges thrown out of office. Or see if we can't get them prosecuted. I just filed criminal charges against my local federal district judge just the week before last. He dismissed on a Rule 12 with prejudice and bypassed a challenge to subject matter jurisdiction. So I took that as criminal due process, procedural due process, and I filed 18 U.S. Code 242 against him. I took it down and gave it to the clerk for presentation to some magistrate, and he stamped it and took it. Now, I haven't heard anything, so I'll go back next week and ask him who he gave it to. And if he can't tell me, then I'll prepare criminal complaints against all of the judges and accuse them all of conspiring one with the other to shield this judge from prosecution in violation of 3805 Texas Penal Code. I'll file against him in the state. What I expect will happen is I'll get a communication before that from a judge giving me sage advice, telling me how I really need to take this complaint to the U.S. attorney or the FBI. And if I get that, then I know which judge to go after. Then I'll file against just one of them. But if I don't get anything from any of them, I'll assume they all got together and all refused to act. So I'll name them all. If one of them didn't have anything to do with it, let him bring it up as an affirmative defense. Maybe we'll begin to get their attention a little.
I hope. Yeah.
Okay, do you have anything else for us?
No, that was it. I just wanted to hear your feedback on where he thought we were headed with this. And
yeah, I'm thinking he knows this is going to come back to him, but he did his job and he was paid to rule in the bank's favor, and he did. But he stayed execution because he's pretty sure this is going to come back.
Right.
And then he has plausible deniability when he rules against the banks. Okay, wonderful. I consider that good news and bad news. Could have been better. Didn't you have a default judgment before the court? Or summary judgment?
Well, we had their summary judgment, which was last year. They filed the judge gave them summary judgment a year ago, and that's what we were waiting to hear about. He kind of put it off based on the information we gave him about the bank holding the construction loan and not the actual mortgage. So he's been waiting this long to make a decision.
Did he give you findings of fact and conclusions at law?
No.
Make sure your lawyer asks for it. Or in his order, did he explain how he came to the conclusion that he did?
I haven't seen it yet because it just happened today.
Okay, generally they do that. And then you have something to appeal. But I'd like to see what his reasoning is.
Yeah. Well, if I get it, I'll email it to you.
Okay, good. Okay, thank you, Chris.
Thanks, Randy.
Okay, now we're going to go to Deborah in Texas. Hello, Deborah.
Hi, Randy. How are you?
I am good. What do you have for us today?
Well, remember I had that default judgment. And this last Wednesday, I went to court and went to the courthouse and filed a motion to strike and to remove the respondent because the respondent is not the defendant. And so anyway, I went in Thursday morning for a hearing again to try to get a signature from the judge. And he told me that since someone filed an answer and that it's, even though it's not my defendant, that we're going to have to, we're going to have like another hearing, and then he wants to hear what they have to say. And I told him, I said, well, that's my defendant, that I should get my motion to strike and my to remove them because they're not my defendant. And he says, well, they say that you got the wrong name and that they're the party in interest and that you should have sued them and that you just put the wrong name down. And I said, no, I know who I sued. And he said, well, you sued the wrong people, you sued the wrong party, so we're going to let them come into court and we're going to hear what they have to say. Well, that attorney that filed the answer also represents the servicer. And they're not, the servicer does, and there's no other parties really in the Denton County land records that has an assignment. And so the people that he's saying has an assignment, he assigned it away from them like in 2015. And so it's...
Deborah, we're going to have to cut you short. We're going to have to go to break. We'll be right back. This is Rule of Law Radio with Randy Kelton, Vet Pack. We'll be right back.
Good news, Patriots. Most Americans now favor protecting civil liberties and personal freedoms over the government's war on terrorism. I'm Dr. Catherine Albrecht, and I'll have more on this major change in public opinion in a moment.
Your search engine is watching you, recording all your searches and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
If you asked Americans after 9/11 whether they'd sacrifice their personal freedoms to fight terrorism, most would have said yes. But now, thank heaven, a lot of folks have come back to their senses. In poll after poll, a majority of Americans, 54%, say they're unwilling to watch their civil liberties go down the drain in the so-called war on terrorism. That same majority also says that protecting people's freedoms around the globe is the best way to stop terrorism, not trampling on civil liberties. It took 2 wars and a decade of torture, warrantless wiretapping, and other abuses, but we're finally starting to see the light. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at LogosRadioNetwork.com.
Yeah, I got a warrant, and I'm gonna serve them
We are back with Rule of Law Radio, Randy Kelton, Vet Pack, and we were listening to Deborah. I'm so sorry I had to cut you off, so please do repeat what you were saying.
Okay. Okay, so I went to court. I went to the courthouse on Wednesday, and I filed a motion, excuse me, a motion to strike and a motion to remove the respondent because they're not my defendant. And so on Thursday,
I had a question. In this person's pleading, did they file a petition and intervention with a prove-up of standing in title?
No, I don't think so. He only filed an answer, and it basically says that he that I've named them by the wrong name.
You need to object. They need to file a petition and intervention and prove up their claim. I could go down there and say, okay, I got a claim against the property, so I'll answer it.
Yeah. Well, anyway, so something that's interesting about this whole thing is that that's the same law firm a year ago that transferred the assignment to Countrywide, who's pretty much been absorbed by Bank of America. And so he says he's representing the trust and
hold on.
But they're not. But they're no longer. They got transferred last year, so he can't be representing them if those people are not. If he assigned that away from them to Countrywide last year and away from the people that he says he's representing in my court case.
Did you bar grieve him?
No, not yet. I wanted to talk to you first. I sent you an email with documents on there.
Did you hear what I read at the beginning?
No, I never could get on.
Oh, this is so good. I did a search for underwriters, for legal malpractice underwriters, and I got a hit on a document, ANON Attorney's Advantage. And there's this article here about know your reporting obligations under your legal malpractice policy. If you send them a tort letter, this is what I was thinking while I was reading it, if they have reason to believe that there's a potential claim against them, they're required to report it to the carrier. If they should have reported a claim and didn't, then they're not insured. So the more claims you report, the higher their insurance rating goes up. So you might email this or send this law firm a tort letter and notice them that they are committing malpractice to your detriment, and order them to cease and desist, or order them to make you whole or be sued, and 3 times the value of the property because you maintain their action is intentionally fraudulent and an attempt to convert your property in violation of the Tort Claims Act. I think it's 139 Texas Civil Torts and Remedies. There's a special cause of action for this that you can sue them under. So send them a tort letter. They have to send it to their insurance company, and their insurance rating goes up.
That sounds good.
And then bar grieve them, and their insurance rating goes up again.
Oh, good.
So you guys want to play hardball? Welcome to the deep end of the pool.
There's alligators, aren't there?
When you go to a lawyer and you bring a claim to a lawyer, the first thing he's going to do is look around and see if he can find some deep pockets to get into.
Mm-hmm.
So we should do the same thing. If the lawyer has malpractice insurance, you're going to sting him big time. If he doesn't, if he's self-insured, you got a nice deep pocket you can get into. So what do you care who pays? You guys want to pay? That'll work for me. You want to pay off my mortgage for me? Yeah, we can do that. So if they have to know if they represented the prior client and there was an assignment from the prior client to someone else, and it's in the record, they've got imputed knowledge. They can't claim they didn't know. Are you familiar with screws?
No.
Okay, since the lawyer is a quasi-public official, he's subject to screws. And if anybody's subject to screws, lawyers are. says if they violate a ruling of this court, and they be saying they may not be heard to say they know not what he does. A lawyer can't violate case law or rulings of the Supreme and claim he didn't know. So since he has to know, if he violates one, you have to assume that he did that on purpose with requisite mens rea, an evil mind, a wrongful purpose. So we really need to sting them good. And you might look at did they file? Look at 39.43, I believe. Let me check and make sure. It's, I'm sorry, I think it's 3249, Penal Code. Let me look it up. 32 Penal, if I got my number right.
Well, I'm sure the judge is involved in it, too.
Pardon me?
I said I'm pretty sure the judge is involved in it, too, because I had a clean little default judgment, and the same day that I went in to get the judge to sign it, he contacted them.
Well, now, you sent me an email about that, but this is civil, and the judge doesn't want bushwhack. He wants everybody to have opportunity.
Yeah.
Okay, here it is. Listen to this. 3249. A person commits an offense if, with intent to defraud or harm another, the person owns, holds, or is the beneficiary of a purported lien or claim asserted against real or personal property or an interest in real or personal property that is fraudulent, as described by Section 51.901C, Government Code, and not later than the 21st day after the date of receipt of actual or written notice sent by either certified or registered mail, return receipt requested to the person's last known address, or by telephonic document transfer to the recipient's current telephone copier number, requesting the execution of a release of the fraudulent lien or claim, refuses to execute the release on request of the obligor or debtor, or any person who owns any interest in the real or personal property described in the document or instrument that is the basis of the lien or claim. Person who fails to execute a release of the purported lien or claim within the period prescribed by Section A2 is presumed to have had intent to harm or defraud another. That gives you a civil claim. An offense under this section is a Class A misdemeanor. So send the lawyer a letter ordering them to remove to withdraw their claim and remove it from their, or execute I keep losing the term, execute a release of the claim from the record under 3249, just for yucks. I'm telling you, lawyers are terrified of the courts.
Mm-hmm.
This will terrify them. I've got one filed against David Stockman. He's one of the biggest trustees that does most of the sales here in Dallas-Fort Worth. And he didn't respond to it, went ahead and sold the property. I just filed suit against him. And now I'll prepare criminal charges and take it to the grand jury. We'll see how this works out for it. And we're turning up the heat around here because I just filed federal charges against Judge McBride. Filed criminal charges against McBride for bypassing a challenge subject matter jurisdiction. So,
Randy, are you ready to go out to break?
I am ready to go out to break.
All right. You're listening to Rule of Law Radio. This is Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back. Hi, you're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Randy, go on ahead. You guys were carrying on a pretty good conversation there, and I cut you off.
Okay, that's what we got her for, because I'm always falling off the cliff and trying to get Vet more comfortable with interrupting me, because sometimes I talk too much, and I. Okay, but anyway, Deborah, we have tools that we can use as pro se's, and we need to start using them better. You're here in the Texas area, and if you start using some of the techniques that I've been using, they're going to know. I was just referred to a lawyer by a guy I work with. I need a lawyer to send a tort letter for me. This is for a company, and I can't do it myself because it's a company. And he said, I called him. The guy didn't respond. And he said, well, maybe it's because he knows who you are. I say, what? He said, yeah, he's already heard about you. Oops. So most of them know about me. And the reason they know about me is because I kick them in their teeth.
That's great.
You're a pro se. You come into the court with powers and abilities far beyond those of mortal attorneys. You're not dangling by your bar card.
Right.
If the judge gets mad at you, who cares? This is not a popularity contest. You want to have an attitude, Judge? Go ahead, raise your voice to me. I'll break you from that habit. Because when he raises his voice to me, then we shift gears. I take off my litigant's hat, I put on my master's hat, and I take my servant to task. Mm-hmm. They're the servants, you're the master. And they will perform their duty in accordance with the law, or you have so many things you can do to them.
Well, I think it's a good idea to sue the attorney because he knows he's committing crime.
Yeah, and you bar grieve him? Okay. This is what I went through earlier. I went through the notice is that the lawyer has to give to their insurance carrier. If they think there might possibly be a claim, if their client complains about something, essentially they got to give notice. The reason that's important is if, when I read this, it stated that the courts have ruled. And it's interesting and important to understand why it said the courts have ruled on what constitutes notice to their insurance carrier. The reason the courts will have ruled on that is because if they don't give notice when they should to their insurance carrier, they're not covered. If they get a bar grievance, they have to tell their insurance carrier. Legal malpractice starts at about $25,000 a year. Wow. 1 bar grievance your first year of practice, they'll cancel immediately. 2 bar grievances, any 1 year of practice, they'll cancel. 3, they'll cancel your law firm's malpractice insurance. Valid, invalid, they don't care. The point I made earlier is if I'm going to go do a presentation to the Sunset Committee for the bar this year, and I'm going to tell them, guys, don't do anything. Leave it just like it is. Just the way it is wonderful. If you file a bar grievance against a lawyer in the state of Texas, state bar is going to get that grievance and they're going to throw it in the trash. And they're going to send you this letter that says, we have examined into your accusation, find it does not rise to the level of misconduct. Doesn't matter what you file, valid, invalid, it don't make any difference. And that's a good thing. And the reason it's a good thing is their insurance carrier knows they're going to throw it in the trash. So how do they gauge their level of risk? By valid bar grievances? Heck, they throw them all in the trash. If I file a bar grievance that says, that no good rotten shyster parts his hair on the left, if you can believe that, he should be disbarred. They're going to send me a letter saying, we examined into your accusation, find it does not rise to the level of misconduct. And their insurance carrier is going to double their insurance premium. Wow. Valid, invalid, they don't care. So the lawyers, by protecting themselves, this is the only profession where a licensed profession polices itself. And they did exactly what you'd expect them to do. They became a public relations organization for the lawyers. They do nothing to police lawyers. And the insurance companies know that. So they don't care what the grievance is. If you get a grievance, you get zapped. I had a lawyer tell me, that's patently unfair. And I'm standing there grinning from ear to ear. Oh, man, I shouldn't have told you that. No, you shouldn't have. And it has borne itself out. Lawyers really get excited when you grieve them. So lawyers have all these advantages coming into the court. They have a political relationship with the judge and your attorney. You go into court, it's like sitting at a 4-sided chessboard. You're on one side, your lawyer's to your right, opposing counsel to your left, judge across from you. You have a relationship with your lawyer. Your lawyer has a relationship with opposing counsel and the judge. And they all have relationships with each other. You're the odd one out. out. So the best way for you to get leverage is sting your lawyer. Now your lawyer has to go to these guys to help you out with this unruly client that's going to ruin my career. You got to figure out how to bring politics into the mix, because you will never win your case simply because you have the law and the facts on your side.
Right.
You win your case.
I've heard you say that a few times before, and now I think it's starting to click with me.
Okay, now you just sting that lawyer. If that lawyer says one word to the court about it, you are grieving for that and ask the court for sanctions, because he is specifically forbidden by the Bar Association standards from mentioning a bar grievance. He can't mention it to the court. He can't mention it to you. Mm-hmm. He can only talk to the state bar about it. But he knows the bar's not going to do anything. But his insurance company is, and he can't do anything about that. So that's why I'm looking up all the insurance carriers, and I'm going to make up a CC list. And I used to have a bar grievance site up, and somebody built it in XML, and it's all crashed. I lost it, so I have to rebuild the site. But I'm building a site, and when you click on send, it will CC the bar grievance to every malpractice insurance underwriter.
Wow.
Everybody gets noticed. And then we'll make up a tort letter, and I want to build a malpractice suit that you can just fill in the blanks. A malpractice suit is way worse than a bar grievance. Now they got to answer it. They got to run the risk of losing it in their insurance carrier. The lawyer himself can't defend it. The insurance company will send somebody in to defend for him, and they are not going to be happy campers. Mm-mm. So it's a way to get us leverage. Judicial conduct complaints against the judge. You don't owe that judge anything. You certainly don't need him to do you any favors, because you can be sure he is not going to. Mm-mm. You don't want him doing you any favors. You want him to determine the facts in accordance with the rule of evidence and apply the law as it comes to him with the facts in the case. If he has another agenda, he needs to get out off that bench. So that's why if a judge raises his voice to me, that's not part of determining the facts and applying the law. That's some personal issue. You want to have yourself a personal agenda? You better leave that at home. You don't come into court and raise your voice to your master. He'll break you from sucking eggs. Mm-hmm. The higher level the judge, the more sensitive they are to the politics. These municipal judges down at the bottom, they're chump lawyers who can't make it as lawyers. So they come part-time and be a municipal judge. So it's not a big deal to them. Even if they lose the job, they don't make much, and they're not the sharpest knives in the drawer. As you move up, these judges are much more sensitive to the politics. Every district judge wants to be on the Court of Appeals. But if he's got a judicial conduct complaint or two against him and another judge doesn't, he's going to get bumped. He's not going to get selected. So This becomes real important to these guys the higher up they get. And you don't need to be your buddy. You know, if he's going to rule against you no matter what, unless you give him a reason not to. And
they're not there for the law, are they?
Right. So unless you make them, you stick the politics to them, they get a lot more careful. So I would suggest you at least get a bar grievance against this lawyer and look up, send me another email and ask me about the tort claim for conversion. I'll look it up. I think it's 138. It's 138 or 139, Civil Torts and Remedies. A special cause of action for someone trying to convert real property. Okay.
Randy, are you ready to take break?
I'm ready. Do you have more for us, Deborah?
Oh, yeah, I just wanted to ask you about...
Wait, hang on. We'll pick it up on the other side. Go ahead.
Okay. All right, you're listening to Rule of Law Radio. Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly.
are listening to Rule of Law Radio with Randy Kelton, Vet Pack. And Randy, you are wrapping up with Deborah.
Yes. Deborah, you had one more issue?
Yeah, there was a couple of things. I wanted to know about how much time should I give the attorney to withdraw his case, but then I was talking to Leslie, and she said maybe I should ask you to recap real quick about how to get them to get removed out of my case, how to get them to decide in my favor, and how to get my quiet title.
It's the one thing about civil is it always takes time. The other side, even if he doesn't have a position, will be given opportunity to be heard. The judge will rule. If the judge rules against him, he'll have opportunity to appeal. And he can keep you in court for another 3 to 5 years. Yeah. So I suggest you sue him.
Okay.
You sue him, and that's why I was mentioning 138. There's not a way to expedite things in court. And primarily for the reason that the judge is thinking, I don't know all the particulars here. There may be a circumstance under which this person, this entity can have a claim. And we have to give people who may have a claim opportunity to state their claim. Now, if they have filed an answer and the answer does not establish their claim, you can ask that the answer be stricken based on a lack of showing of jurisdiction. And you might get it tossed, but even if you do, they're going to have opportunity to appeal. It's going to take a long time.
Well, the reason that I have my default is, one, the statute of limitations is completely out, so there is no creditor. He can't claim to be a creditor for his.
Okay, so it's irrelevant.
So that they didn't file, how they get 21 or 20 days. Well, they didn't even file an answer for 20 days after the default date.
Okay, so you're not asking for default based on failure to respond. You're asking for default based on statute of limitations.
Yes.
So you can file a response saying that their answer is moot. It's irrelevant whether they have a claim or not. They're subject to laches. Are you familiar with laches?
Okay.
Laches is where you have a right, but you sit on your right and don't exert it. Right. If, in fact, they had a claim, they had ample opportunity within the statutory time limit to state their claim. But that time limit's passed. And regardless of whether or not they have standing as a lien holder, they're out of time. So it makes no difference who they are.
Exactly.
Sometimes it's important we take on the right issue. And the real issue here is not whether or not they have standing as a holder, but they have no standing because statute of limitations.
Correct.
That's probably going to fly. But the judge has to give them opportunity.
Even if they're the wrong party?
Even if they're the wrong party. If you filed an issue on the other side, I said, oh, well, they don't have standing, you would expect the court to hear your argument for standing. You wouldn't want the court to just blow you off out of hand. And what the court, when you mentioned that the court notified the other side, that's what they're doing. They're making sure these guys are given an opportunity to assert their side. It's very unlikely that they're going to win this thing.
Okay. Well, it's funny. They intrude on my case, and then they put on their answer that I have to pay all attorney fees and all of that stuff for them.
You need to send them a tort letter.
Okay.
And go read 32.49. Texas
yesterday.
Texas Penal Code. That's what's criminal.
Yeah. I read it yesterday, and I gave it to Leslie yesterday because I told her that's what I was thinking of doing.
Oh, it can't hurt. I mean, it's like chicken soup. It couldn't hurt. When you file criminal complaints, you have the same protection a judge does.
Mm-hmm.
And if anybody says anything to you that you could in any way take as a threat, they generally couch threats under fair warning. When I go into these places, if I get a police officer or a bailiff or somebody say, "Oh man, you got to be careful. You come in here filing these complaints, you could get in trouble." 911 immediately. That's witness tampering, obstruction, official oppression. You want to threaten me, Bubba? We'll see how that works for you. Well, I'm threatening you. Well, I took it as a threat. You should have kept your mouth shut. They don't like it when we take their code back to them. When I went into the federal court and asked, where I needed a judge other than Judge McBride. Well, you can't see the judges. We'll take that up with the judge. So, oh no, you can't see. Look. I said, look, I'm going to go up and I'm going to file this criminal complaint. And if anybody interferes with me in any way, I'm going to call you and ask you to arrest them. And the marshals, their whole demeanor changed. Ooh, we can't arrest him. I said, sure you can. You're the marshals. You're here to keep peace. So I'm here to file a criminal complaint. If anybody threatens me, that's witness tampering. I'm going to expect you to arrest them. Well, nobody's going to threaten you. I said, well, I hope not. They really don't like it when you bring it back to them. And you have, you're in a good position. Statute of limitations is a strong argument. But I would, if I was the judge, I would want to give the other party opportunity to make his case.
Okay.
In his answer, did they reference statute of limitations?
No, they didn't.
Okay, so they didn't put in an argument saying why the statute of limitations had not told. So if they haven't addressed that, then you might file another petition for default judgment based on their answer.
Okay.
Because they failed to address statute of limitations. So they waived their claim. If there was a reason why the statute of limitations should toll, they had to state it in their answer. If they didn't, they waived it. And that is dispositive. Nothing else matters. You can't get past it.
Oh, I feel so much better.
Did you file a response to their answer?
We filed a motion to strike and a motion to remove them.
Now file in the alternative, file a motion for default judgment. The motion for default judgment may actually get it removed. Because if you can show that it doesn't make any difference.
The judge says I need to set it for hearing. So do I? So I can file that on the basis that they didn't address the statute of limitations. Okay.
Exactly. So you go ahead and file for default judgment to show they don't have a claim. Even if they have standing, they don't have a claim. So their answer is moot.
Oh, that's right. Wow, it sounds like we just won my case.
Sometimes the hardest thing to do, especially when you're inside the case, is to see what the right thing to argue is. Mostly the other side beats us on procedure. And the next time I get in a case, I'm going to ask you to look at it and show me what I miss. Because we get inside it and we get into the fight and we get caught up in all the details. The only reason I could see that is I'm not caught up in all the details.
Mm-hmm.
So you need other people. I need other people.
She's my rock, that girl.
Oh, this Leslie. Ooh, she's tough.
She's my rock. I don't know what I'd do without her.
and I love her work. She does beautiful work.
Doesn't she?
I aspire to do as nice a work as she does.
Yeah, she's wonderful.
And I don't ever want her coming after me.
I don't blame you.
I don't call her bad grandma for nothing.
Yeah, that's cute.
Okay.
She's precious. She really is. Oh, thank you so much, Randy. I appreciate it. That really answers all my questions, and I feel so much better.
Okay.
Thank you all, and have a good evening.
You too.
Thank you, Deborah.
Bye.
Okay, now we're going to go to Scott in Texas. Scott, you've been chumping out the cops lately.
Yeah, I got a little question here. I had my court date in Rockwall, And they just sent me a letter. I had it all set up where I didn't have to go till August 4th. And now they just sent me a letter saying that they want me to come to a summons to appear for docket call on 6/27. So like 3 weeks from now. And it was
docket call
from now. Yeah, I don't get that.
Okay, look up 28.01 Texas Code of Criminal Procedure.
And
okay, let me do that real quick. Okay, what that one is, let's see, 28.01 TCCP. What that is that authorizes the judge to summon you to court. 28.01 pretrial. The court may set any criminal case for a pretrial hearing before it is set for trial upon its merits and direct the defendant and his attorney, if any of record, and the state's attorney.
Randy, we're going to have to go to break. This is Rule of Law Radio. Randy Kelton, Vet Pack. We'll be.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
Hey, we are back with Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Randy, go right ahead. You're talking to Scott, and you're going on and on and on, and I had to cut you off.
Yeah, Vet interrupted me. I was doing my run-up. I was fixing to do a swan dive right off the cliff.
Yeah. Lucky I saved you.
Okay, 28.01 pretrial. The court may set a criminal case for pretrial hearing before it is set for trial upon its merits and direct the defendant and his attorney, if any of record, and the state's attorney. Pay attention to the fact that it says and. That they have to, if they set a pretrial hearing, they have to direct everybody to be there. The defendant must be present at the arraignment, and his presence is required during any pretrial proceeding. The pretrial hearing shall be to determine any of the following matters: arraignment of the defendant, if such be necessary. Arraignment is 26.01, 26.02. Arraignment is for the purpose of identifying the accused and setting a plea, and that can only be had in a felony or a criminal claim punishable by imprisonment. Otherwise, you can't have an arraignment. Okay, an arraignment of the defendant, if such be necessary. An appointment of counsel to represent the defendant, if such be necessary. Pleadings of the defendant. Special pleas, if any. Special pleas, challenge subject matter jurisdiction, double jeopardy. Exceptions to the form or substance of an indictment or information. Motions for continuance, either by the state or defendant. Motions to suppress evidence. Motions for change of venue. Discovery, entrapment. Motion for appointment of interpreter. Okay, which one of those are you being required to appear for?
Well, this is Class B, so you could go to jail for it.
No. What does the notice to appear advise you of as the purpose of the hearing?
Your summons to appear before the county court, location, your court date has been set for. It just says summons to appear for docket call.
Okay, in 28.01, where did you hear docket call?
Oh, well, I didn't.
Right. File a complaint against a judge for abusive process and file an objection to the appearance.
Well, this came from the county clerk.
Don't care who it came from. It come by authority of the judge.
Right.
Or in the alternative, a request for clarification.
Well, I'm just wondering, couldn't a person just send them a letter back saying, hey, we already have a date agreed upon, that date is already taken?
No. This is you've been commanded to appear. They're going to look for a reason to charge you with failure to appear.
Right.
So you challenge this notice as insufficient. You maintain that it's not in keeping with the Texas Code of Criminal Procedure under Article 28.01. I have never found a judge who knew what was in 28.01. They never read this stuff. They just do whatever the heck they want to. So this would be fun. Send it back in an objection. This is not it wasn't as a pretrial hearing. Have they heard all your motions?
Well, they just heard that one, and I challenged subject matter jurisdiction, got overruled on.
Do you have any more motions before the court?
Not yet. I just got out 2 days ago.
Then they have no authority to command disappearance. This is just to harass you. This is abusive process.
Yeah, this is totally abusive. I just went to court like
abusive process is a crime, and it's a procedural due process violation. So send him back in opposition to the hearing, asking for clarification under 28.01.
Would I title it this opposition, or what do you want? Would I title it that?
Yeah, it's just okay. I'd have to read their document, but they sent you a notice to appear. The notice to appear does not give you adequate notice of the purpose of the hearing, as you don't know what a docket call is. And docket call is not authorized as a reason to order you to appear under 28.01. If there is some other statutory authorization, demand it. Otherwise, demand them to strike this hearing. It's just touching all the bases. There's not a prescribed way of writing it.
Okay.
Take this hearing date and cram it up your... Nah, that probably won't work. But just challenge it because they didn't tell you why you're going to be there. You don't know what docket call means, and you can't see that the court has any authority to call you for what you think a docket call is. I mean, what is a docket call? They order you to show up so they can see if you showed up.
Right. And then they can start the process and speed it up because I got to postpone for 3 months.
Yeah, that's abusive process, and challenge them with abusive process. And is this the county court that you're...
Yeah, this is the Rockwall County one.
Yeah, then send them that. Now this one goes to Liberty, so send them that motion to dismiss based on res judicata. Make this thing go away.
Did you read the res judicata that I sent you? Because I just worked on that.
No, I saw it, but I didn't get to it today.
Okay.
You didn't help me with AutoCAD, so I was stuck.
Well, I had crap to do.
That's what I always hear. I had to go give my cat a bath.
I don't have a cat.
Okay. I will get to it tomorrow.
All right. Well, then I'm going to look at it. And then you were mentioning something about the cops. I mean, the lawyers. Yeah, their bonds and stuff. So what about the cops? Couldn't the same principle apply to them?
Okay. What cops? What are you talking about?
Well, you were talking about when you file, or you wanted to get all the bonding companies' information, and then that way you could see them, right? Or basically you could go. Couldn't you go after their bond and file a lawsuit against the bond?
I have heard that, but I haven't found a way to do it. You don't sue the cop really anyway. You sue the city. You sue the municipality.
Well, I was just wondering if it would also affect their bond and make it go higher too.
It will. It'll make the cities higher. But when you sue based on a cop's misbehavior, you actually sue the city. And yeah, that'll make their bond rating go up. And not the individual officers. They don't have an individual bond. But if they force the city's bond rating up, the city's not going to be happy with the officer.
I get it.
Everything rolls downhill. So if you want to request bonding, they don't really have to give that to you because insurance is between the insuree and the insurer. You as a third party don't have anything to do with that. You sue the insuree, and the insurer must indemnify the insuree, not you.
Correct. Correct.
So you can't sue the insurer. All you can do is give them notice, but the city's different. They'll get notice when you sue.
Randy, are you ready to go on break?
Yeah, just about. Are you going to talk about the cops today when we come back, Jeff? Scott?
Yeah, we'll go ahead.
Okay, go ahead, Vet.
All right, this is Rule of Law Radio. Randy Kelton, Vet Pack, 512-646-1984. We'll be right back.
A Dutch scientist has a recipe for saving our planet and feeding the world. And it's not just pie in the sky, though you might wish it was. I'm Dr. Catherine Albrecht, and I'll be back with his creepy, crawly food plan in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
What has 6 legs, 2 antennas, and a proboscis? Arnold van Huys's dinner. The Dutch scientist eats an insect and worm-based diet, and he thinks you should too. He makes the case that bugs and worms multiply quickly, they're cheap, and they're a great source of lean protein. Plus, they don't cause the pollution that cattle do. While eating insects and worms might be logical, Van Huys knows he has to overcome some pretty serious barriers to the idea. After all, we're used to squashing bugs, not eating them. So he's working with gourmet chefs to create bugalicious dishes like deep-fried cricket, mealworm pie, and chocolate pralines with buffalo worms. Dessert, anyone? I think I'll pass. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails.
Looking for some truth? You found it. LogosRadioNetwork.com.
You are listening to Rule of Law Radio. Randy Kelton, Vet Pack. All right, so we're listening to Scott. Go ahead, Randy.
Okay, Scott, you were pulled over by the Mesquite police today. Will you kind of tell about what happened there?
Yeah, I was leaving the gym, and I was coming back down this little road, and cop pulled me over. Well, I saw him look at me, and he flipped a U-turn, and I figured, okay, the guy's going to pull me over. You just get that feeling. And so I pulled into a private parking lot, which everybody should, so that way they can't steal your stuff in case you do have to go to jail. But so anyhow, the cop pulls up behind me and immediately comes out and says, I need to see your driver's license and stuff. And I already had a prepared right to travel document. It states all kinds of case law with screws in it and everything, And I told him, I said, well, I just need you to read this document and sign it, stating that you're going to violate my right to travel. And immediately he calls in on his mic and goes, I need a supervisor. And so I said, just read the license plate, man. That's all you need to do, I guess. And we're good because he wanted my license. He saw my license in my wallet, and I wouldn't give it to him. He goes, well, I just need to see your license right there. I said, no, I need to give you this. Well, anyhow, about a third of the Mesquite Police Department shows up, and they all are sitting there talking and looking at it. And I guess the supervisor looks at it or blah, blah, blah. And he come over, and then this other guy that comes over, I don't know who he was, but he started grilling me. And then, because you get the standard procedure here now where they're just going to wring your butt out. And so called me a constitutionalist and all this other stuff. It was kind of funny, but anyhow, they were at the one cop asked me, he goes, well, you got to sign this or you're going to go to jail. I said, okay, I'll put on there under duress and signed it, and here you go. And he goes, when's the last time you've been to jail? And I said, well, I can't recall. And he said, oh, we know exactly. It wasn't that long ago. And he said they already saw Rockwall in there and how I've been going through that little scenario. And so, anyhow, that's when the other cops started going, well, you think you're a constitutionalist and all this stuff. You think you know the law. It sounds like to me you've been getting some jailhouse lawyer advice. And, you think you're writing this stuff up. And he started, gives me the ticket, and I realized that it has a invalid license on there. So I whipped out the Dallas County Court papers and said I had this already adjudicated and dismissed.
And they wouldn't even, they looked at it, and I told them what it was. I said, here, this case has already been dismissed for invalid license, and you can strike that. You know, we ain't reading no more of your documents, and we're going to keep this other one. And, you know, he started giving me all kinds of grief and stuff. And he kind of got really cocky, and he said, well, what are you going to do? You know, you going to leave? You know, if you leave, you know, you're going to get arrested, you know, because you're going to be driving with an invalid license, you know. And I said, so you're telling me if I leave out of this parking lot in my car, I'm going to jail? And he said, in fact, you know, you just need to beat feet practically and just walk on out and see if you can not violate law with that. I bet you can't do that either. I said, you just say you're just going to try to arrest me? So I can't tell you what, you know, I don't know exactly what he said. But anyhow, I said, well, what are you going to do? I said, well, I guess I'm going to walk into the store right here. And he said, well, they might not take American money. You're a constitutionalist. You know, I guess he knew the guy inside was from overseas or something. And so he said, you know, you're a constitutionalist. We may not take your money. You may get shot in the head. I said, are you telling me I'm going to get shot in the head now? And so
that cop actually said that to you?
Exactly.
Oh.
I wish I had.
Did you record him?
Bragging. I didn't get him on recording, but he was bragging how he got it all. They were recording everything on me with their body cams and all this other stuff. So I already got an information request that's going to go in immediately and see if I can get that. But yeah, so I get out of my car and I don't have a shirt on because I just got done working out, you know. And so he's like, "You put your shirt on." I'm public, you know. If you go in the store, I said, well, when I go in the store, I will, you know. He goes, we'll be seeing you. I said, no, you won't. And I walked in, I grabbed a cup of coffee, and the guy said, like, what's that all about? I said, come back, because I don't have a license plate in the front of my car. And just give me all kinds of grief. He goes, yeah, he was grumbling. He didn't. So anyhow, walking outside, we're across the street now, just waiting on me to do anything.
Wait a minute. Scott, we're having trouble with your sound.
Okay.
And get to the salient stuff. We don't need all the peripheral details. Where's the beef? Scott, did we lose you altogether? Yep, we lost Scott. Oh, well, what happened was he called me and told me that they were out there waiting for him to leave. So I had him call 911, and within 30 seconds of him calling 911, all these cops dispersed. Okay, Scott, you're back.
Yeah. So,
I just summed it all up and finished up your story for you while you were calling back in.
Yeah. So immediately called 911, and while I'm talking to him, the cops drove past, and one of them was waving. And while I'm on the phone talking to 911, and so then he came back and was sitting there trying to talk to me again. I'm sitting there standing on the phone talking to 911, and then they drove completely off. Well, I couldn't. They wouldn't send a cop out there because there's a cop already there. So he said, we're going to have to get our sergeant to call you back. I said, well, you need to have him call me right now. He said, will you feel threatened? I said, yeah. I said, one cop was telling me he's going to arrest me if I did anything, if I left his parking lot or did anything, and he's talking about shooting in the head. I don't know what's going on with this guy, you know? So, yeah, I feel threatened now. And sure enough, everybody smooth on off. So, yeah, it was a mess.
The point of the story was 911 works.
It does.
They really don't like it when you call 911 on them.
That's twice I've done it now. And it really does snap their head around and get their attention. Because when you start calling the cops on the cops, oh, they get dinky.
It ruins all their fun. Okay. Wonderful. Okay. Do you have any more, Scott? We got a whole bunch of callers.
No, I'll let you go.
You did good.
Well, y'all have a good evening.
Okay, thank you, Scott. Now we're going to go to Gary in. We're going to go to Ken in Texas. Hello, Ken.
Hey, Randy, this is Ken.
Yes.
We got a real bad echo on the line.
You might want to recall. I don't have any on my end.
Okay, Scott's call while I was waiting on hold had a lot of echo on it too.
It's probably your connection, because I didn't get any echo on his side. You might want to hang up and call right back. That might fix it. You there? Well, he must have hung up. Okay, now we're going to Gary in Texas. Hello, Gary.
Hey, Randy. What's up, my friend?
what do you have for us? This is the Gary. Okay, been a while.
Well, to me, I'm the Gary. Yeah, I agree with that. Hey, by the way, there is an echo. I agree with your buddy that there is an echo on all the calls.
I'm not having one on mine. We're about to go to break here in about a minute. I'll have our producer look at it and see if he can figure out what's going on there.
Yeah, well, you know, I know you have those specially modified headphones that doesn't hear any of this stuff.
Yeah. Yeah. Well, I hear my voice come back. Can you hear the stream, or you get an echo in your headset?
I'm getting echo in my headset.
Okay, I'll have Robert check the stream to make sure it's not going. Okay, the producer tells me that the stream sounds fine. Hang on, Gary. We're about to go to break. Go ahead, Vet.
All right, this is Rule of Law Radio. You're listening to Randy Kelton, Vet Pat. Please call us at 512-646-1984. We'll be right back. Easy.
Well, you know, karma's lurking around the corner. You better watch every step you take. The good and good will follow you. Yeah, the journey. It's in reality. Okay, karma's lurking around the corner. Sing, Jerry, come!
As we sow, so shall we reap. So many crucial works get put on. Oh, how we see.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Okay, so we were talking to Gary in Texas. Gary, go ahead. What's going on?
Okay, thanks a lot. Yeah, so anyway, a question. I own an automobile that someone was using, and they got stopped and accused of having miscolored license plate lights and an unreadable license tag. And so I, as the owner of that automobile, I wrote an affidavit up, took photographs, and which clearly proved that the lights are the proper light, proper part number. They are certified by the manufacturer of the light bulb to produce a white light only. Anyway, so got a nice affidavit, got nice prints, and the court refused to allow the accused to enter that affidavit into the record. So I would like to know what can be done to get them to accept the affidavit.
Well, first, I would file criminally against the judge. Procedural due process.
Okay.
And then move to recuse the judge for judicial incompetence. That's a procedural due process violation. That's official oppression. That's a crime in Texas.
Mm-hmm. Okay. How about the court clerk, who was the spokesman, would not allow the affidavit to be filed?
So the court clerk is the judge is respondeat superior for the clerk.
Okay. Gotcha.
It's even better when you go after the guy who had nothing to do with it. He is not going to be happy when the clerk gets him accused criminally.
Yeah, okay. All right, that works for me. Just an observation, Randy, we're talking about the public taking action against public officials that violate their, that violate state statute, perhaps violate their oaths of office, violate whatever. And I just wanted to point out something. I was thinking today about one of the political candidates, Mr. Trump, how he has gone publicly against a judge and accused him publicly for being biased and prejudiced in handling a case against one of Trump's corporations, and also went public against the presumptive Democratic candidate for president, accusing her of high crimes and saying she needs to be in jail. And I thought, I don't know a whole lot about Mr. Trump, but I will say that he's proving that the public can have a tremendous effect against these questionable public officials just by opening his mouth and saying something. And just Bob,
absolutely.
I myself and other friends have been so timid about doing this. And I'm thinking, look at the example that's on a national scale right now. This guy's fearless. So just an observation.
Yeah, and more of us should be. It's not as big a problem. We're terrified of doing this, and there's no reason to be.
No reason at all.
Yeah, this is our duty. He's accusing Clinton of outright lying, and
yes,
it's clear that she violated. I forget what it was specifically over the emails, but it's clear she violated the secrecy laws in putting these sensitive emails on a private server. She knew she wasn't supposed to do that. She didn't care.
She's a high-powered lawyer. She has no excuse and can't claim ignorance of the law. She's an officer of the court.
Yeah, but she can't recall.
Yeah, right. The other thing, she lost over 30,000 secured, private, classified emails. They're just missing. If I misplace my driver license and don't have it, I get questioned like crazy for just a stupid piece of paper. Should I get stopped? So it's incredible. It's outrageous. And the public is so asleep at the wheel on all this stuff. I mean, there's criminal things that are getting exposed, and it's like almost nobody's batting an eye at. They go,
wait a minute, Gary. Look who won when was the last time you saw someone conclusively win the nomination months before the caucuses, months before the convention?
Yeah, well, that's a good point you're making.
And look who's there. The Republicans hate him.
Yeah.
The Democrats hate him. This says the public's fed up.
Well, I was reading some comments today on Yahoo Mail or Yahoo News, and you know how credible they are. Anyway.
Hey, if it's on the internet, it has to be true.
I know. They had an article about Clinton and about how something she said today, and there were 1,033 comments, and every one of them talked about what a criminal she is. And so the public is not buying the lie anymore, at least in her case.
Look at that's the only thing I can say is Trump is an indication of how disgusted the public is. And frankly, I don't care what Trump's position is. I don't care what he thinks. He will be a gadfly. He will be somebody that's not under control by either party. And I can't think of anyone better to have. Just because he's not in anybody's pocket.
Well, I pray for him every day that he doesn't get Vince Fostered. You know what I mean?
Yes. Well, I'm hoping he don't. But anyway. But if we had him in as president, these other countries that's been dealing with these politicians, now they got a businessman. And somebody who's not reluctant to tell them to go scratch. You don't like the way we're doing it? Hit the road, chump.
Well, it sure appears that way. And just by way of, and this is not meant to promote him. I'm just promoting what the stand that he's taken against this judge that's handling the case against him. He just went public and came down hard on that judge. But look at what he's done, like with that, who's that CNN reporter that did the debates? Megyn Kelly, is that her name?
Yeah, I don't remember that one.
Yeah, she's just beautiful and got eyes that are wicked. He destroyed her. She's not there anymore. The other one, Katie Couric, she's history. And now it looks like this Hillary is in serious trouble, and this guy Bernie Sanders looks like he could take California and win the nomination because her credibility is history. Nobody's ever challenged it publicly before.
There's a story about Richard Nixon when Hillary Clinton. She was an aide in the White House when Nixon was in, and Nixon wanted nothing to do with her because he considered her an unscrupulous liar. And this was when she was 26.
Yep.
So she has a long reputation of this position.
Yeah. Well, it's just real interesting to watch. But, the whole point of me bringing this up is that this should be maybe a life lesson for those of us who have been trying to be timid and respectable, and maybe in the back of our minds concerned about retaliation. We don't need to be. If they retaliate, it's worse for them.
Exactly.
They need to toe the line when it comes to us, because we're the ones that write the paychecks. We're the ones that put the lawmakers in place. Those are our laws, our statutes, and it's time for them to shape up or they will ship out.
Yeah, the last thing they want us to know is how powerful we really are.
That's right. Yeah.
Okay. Hey, thanks a lot, Gary, and don't be such a stranger.
Yeah, and listen, thanks for letting me call in. I appreciate it. It's a really good show tonight.
Thank you. Okay, now we're going to go to Ken Magnuson. And Ken, you got 15 seconds.
Hello?
Okay, yeah, you got 5 seconds left. Hang on, we're about to go to break. We'll pick this up on the other side. If you're getting an echo, and Gary was getting an echo, but Robert checked it and it's not going out on the air, so we're okay. Okay, go ahead, Vet.
All right, this is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Please call us 512-646-1984. We'll be right back.